Yes, sir. Good morning. So you're on mute. I think again you've gone on mute, sir. You're again on mute.
It's not unmuting.
Yes, yes. Now you're audible. Now you're audible.
Oh, there must have been a little bit of a lag. Good morning, ma'am.
Good morning. Good morning. Welcome to Symbiosis. Welcome back to Symbiosis.
Yes, sir.
So we have at approximately 110 students who have joined us. Now we're expecting a few more students to join in, and we will. I think we can begin the workshop since it's already time.
Yes,
so the time was 11:30, so 1 minute to go, and then we can start.
Not a problem, ma'am. We can
The
wait.
student team is ready, and the teachers have also joined us.
Oh, great.
Teachers in charge, a few of them have joined us. We have Dr. Nilesh Wagmare, sir, who has joined, and Dr. Swati Chine, ma'am, who is the head of Department of Business Laws, in collaboration with which we are doing this particular workshop.
Yes, ma'am. Thank you.
And we have another faculty development program going on. So principal sir would not join us today, but tomorrow morning for sure he's going to join us.
Oh, great. That'll be great. I haven't seen Soman sir in a very long time.
Everybody was very excited, when I said that Gokul sir would be taking the workshop. So all of them, like teachers who you and Soman sir, everybody was excited.
How kind.
Okay, so Manish, are we good to go? Should we begin?
Yes, ma'am, we're good to go. A very good morning to everyone present today. I, Manish Agarwal, on behalf of the SCAC Center for Innovation and Entrepreneurship, would like to welcome our esteemed speaker, Mr. Gokul Narayan, for being there to guide us on a very important topic of intellectual property rights. Sir has joined us all the way from Delhi, and we are very grateful to you, sir, for sharing with us your expertise and time. I welcome our principal, Dr. Rishikesh Soman, Vice Principal, Dr. Tessie Thadathil, Head of Department of Business Laws, Dr. Swati Chine, Head of Center for Innovation and Entrepreneurship, Dr. Shrayu Bhakre, Professor in charge of this program, Dr. Nilesh Wagmare, all the faculty and the students of our college for this two-day workshop on intellectual property rights. The workshop is organized in collaboration with the Department of Business Laws SCAC and has been possible because of the RUSA funding received by our college for entrepreneurship and skill development. It is my pleasure to share that the Center for Innovation and Entrepreneurship, CIE, of our college endeavors to foster an entrepreneurial ecosystem in the college and provides the students with a platform for starting their own ventures. The college has also constituted an Institutions Innovation Council as per the guidelines of Government of India's Ministry of Education, with a vision of infusing innovative and entrepreneurial acumen amongst the students. I would now like to invite Dr. Shrayu Bhakre, Head of CIE, to speak a few words. Over to you, ma'am.
Thank you very much, Manish. And at the outside, I would like to once again welcome our esteemed speaker, Gokul Narayan, sir. And sir is our own faculty. He has been a faculty for our liberal arts program for many years, and therefore he's a very familiar personality in our college, a very favorite among students. And what his strength is that he can easily connect with the students through his sessions. And that's why, sir, we are really happy to have you here. And we just hope that all our students make the most of this workshop, which you will be conducting for them for 2 days. So students, intellectual property rights actually is a very relevant and an important dimension of entrepreneurial skill building. In fact, if you want to be an entrepreneur, or you want to go ahead and be an innovator or a creator or an author or a designer, in any of these areas you want to make a career, I think it's important you get to know, at least you're aware about intellectual property rights. In countries like Japan and South Korea, what we see is, this particular subject is a part of school curriculum. And unfortunately in India, we don't see this, but in the domain of higher education, we can see IPR and all other aspects, dimensions of IPR being included. specifically if you're going for law, or even if you're doing a commerce degree, a conventional courses, you do have certain aspects of this particular of IPR being included as a part of curriculum. But in school, it is we don't see this being very familiar with the students. So that means what? That at the school level itself, they emphasize on their students, young minds thinking innovatively, thinking about innovation, thinking about creating something new, thinking about coming up with novel ideas, which is actually quite absent in our school education. So when you're in the college, we believe, specifically at Symbiosis College of Arts and Commerce, that all of you, as students of our college, be aware of intellectual property rights. Therefore, we have it as a part of our curriculum also. So therefore, as a part of Department of Business Laws, this is taught as a subject in third year. And we also have small courses under liberal arts for IPR. So this workshop, aims to bring out a lot of innate aspects of IPR, and so that you are more familiar with the subject of IPR and what actually comes in that. Today's will be a session format where sir will talk about intellectual property right in the digital era, and tomorrow it will be more of a workshop kind, where you would be learning more application oriented things related to copyright. So students, if you are thinking of going ahead and doing something new in whether as an author, writer, designer, brand marketer, an entrepreneur, lawyer, I think this is what you should be attending. So welcome to this workshop, and we hope that you make the most of it and derive a lot of benefits from this workshop. Welcome students, welcome dear teachers. For this particular workshop, sir, I would like to thank our principal, Dr. Rishikesh Soman, for supporting. Also our vice principal, who's always there to help us. IQAC coordinator, our Anil Adagale, Dr. Anil Adagale, sir, because this is possible since we have RUSA funding, and all my other teachers have always been there to support. And a very strong student team, sir, is working to enable these programs to happen. So this workshop is a kickstart for all the activities which we will be conducting under RUSA in this month of Jan and in the month of February. So thank you to everybody, and welcome sir once again. Over to you, Manish.
Thank you, ma'am. So the workshop will be conducted for the course of 2 days, today and tomorrow, that is 27th and 28th January 2022. The topics that shall be covered during this duration are of relevance to intellectual property rights, specifically in the context to the current digital era and fundamentals of copyrights, providing a detailed understanding and application of the same. As the world progresses rapidly towards a predominantly digital era, it becomes very imperative for budding entrepreneurs and intrapreneurs to be aware of and to understand their intellectual property rights, as well as have knowledge about patents and copyrights. This workshop will provide them with the competitive edge and allow them to protect and grow their ventures. To talk on this relevant, complex, but at the same time a very important topic in a simplified manner, we have with us an expert in the area, our very own Mr. Gokul Narayan. He is an educator as well as an entrepreneur having expertise in information technology law and intellectual property law. Mr. Narayan has pursued his master's in law from Symbiosis Law School and is currently working as the Chief Operating Officer at the Asian College of Cyber Laws. He has had an illustrious career spanning over 16 years, where he worked for numerous prestigious organizations like Knowledge Exchange Institute in New York, Symbiosis School of Liberal Arts, and Data 64 Techno Solutions, to name a few. Mr. Narayan has also curated and conducted courses on cyber law, intellectual property rights, tort law, and legal awareness. We kindly request all of you to remain with us throughout the 2-day workshop so you don't miss out on any important updates. Also, please note that the process for availing your certificates will be communicated as we progress through the workshop. So make sure to not leave the session midway. Now, without any further ado, I hand over the platform to Mr. Gokul Narayan, sir. Welcome, sir.
Thank you. Thank you so much, Manish. Thank you so much, Dr. Shareu. Thank you so much, Arts and Commerce College, Dr. Soman, Tessie. Thank you so much. It's a pleasure being back. It's always really nice coming back to the Arts and Commerce College, since my entire introduction to the idea of liberal arts and teaching in the format that I do teach in was through Anita Patankar way back. It's been a really wonderful journey interacting with the students at Arts and Commerce College. So when let's get into the conversations that we're going to have itself. So when we're speaking about intellectual property, what I would like hopefully to happen is that we can have a conversation about this. Obviously, I'm going to be giving out certain information to all of you. I'm going to be speaking about intellectual property. I don't want you to hold back with your questions. At any point of time, if you have any questions, don't wait till the end. Now, what generally happens is if people wait till the end, at least in my experience, they tend to forget the question. They tend to start thinking whether this question is relevant or not relevant, and so on and so forth. I would request all of you to feel free to have any kind of conversations with me as far as intellectual property is concerned, and whatever questions that come to your mind, just feel free to ask them. So let's begin with the conversation that we're going to have. What is intellectual property? Why are we studying it? Why is it relevant? How is it that it has gained so much of importance over the current years? To begin with, now, intellectual property theoretically as a concept and as an idea is not new. Right? It's been there since the time the Gutenberg press came across, since the time the first versions of the Bible were actually handwritten and then copied. The idea of intellectual property has existed since then. It's obviously transformed over the years. It's become something that that was first initially created only for works that were written and then transformed into what it is today in the digital era, where it protects everything starting from books to non-fungible tokens, from technology to chicken actually grown in certain parts of the country. So it literally covers everything. So let's begin with that very basic, simple question. What is intellectual property? Intellectual property, as the name itself suggests, is any property that has been created with the application of the human mind, the human intellect. So as you see, wherever you're sitting right now, as you see around you, you will be surrounded by intellectual property. First of all, the device that you access this workshop on is intellectual property. The furniture that you're surrounded by in the room that you're sitting, that is intellectual property. The lights that are there in the room, that is intellectual property. The fan, the camera, the glasses on the table, literally, you're just surrounded by intellectual property, whether it be something like this globe. I've got a little globe on my table, to this Royal Enfield Bullet miniature version that I have. All of this is intellectual property. So in a nutshell, intellectual property is any property which is created by the application of the human intellect. सब कुछ intellectual property के दायरे में आता है. All of it fits within the expanse of intellectual property. Now, another way of understanding it, let me give you an example. There's a difference between versions and forms of intellectual property also. Intellectual property, let's take, this is one of my favorite examples, so I'll take that and try and explain it to you. Intellectual property is there in the simplest motorbike to the most complicated car, right? Intellectual property, right? Intellectual property is there in every such concept. So for example, let's take a very simple motorbike like a Hero Honda. No, let's take more common, even more than the Hero Honda today, is the Honda Activa. Very, very capable 100 to 125 cc motor, automatic clutchless scooter, which is available in various colors and has been dominating the Indian two-wheeler market, especially in the non-geared category. And that's one end of the spectrum. I don't know how much it costs as of right now, but I would guess the top end of the Honda Activa should be anything between 65 to 75, 80,000 Indian rupees. Right, that is one end of the spectrum. Then at the other end of this spectrum is something like let's consider a GS1250. It's a BMW motorbike. It fits into the category of what is referred to as an adventure tourer, very capable, 1200cc. So Honda Activa is 125cc approximately, and has about 8 to 9 bhp of power. That's the number of horses. In comparison to horses, the number of horses that are there in the power of the number of horses that is there in that scooter, it's about 8 bhp. On the other end of the spectrum is the 1250cc internal combustion engine, which is there in the BMW, which churns out something like, I think in excess of 130 bhp of power. एक end of the spectrum पे हमारे पास एक 80,000 रुपए की बाइक है. And at the other end of the spectrum, we've got a bike which I think in Delhi on road is about 23 lakhs. Now, both have intellectual property in them. Now, एक 80,000 की और दूसरी about 22 lakh की. इसमें, so if we consider how much of raw material goes into creating these bikes, which will include metal, steel, plastic, forms of alloy, rubber, glass, all of these raw materials. So if you look at the cost of raw material that goes into building an Activa, I think I would put in, because I'm not considering sales cost, assembly cost, marketing cost, sales cost and all that. मैं consider नहीं कर रहा, मैं सिर्फ cost of raw material बोल रहा हूँ. Cost of raw material in an Activa, I will put it down at around 20,000 rupees, 15,000 rupees cost of raw material. 15,000 रुपए का raw material लगा होगा एक Activa को बनाने में, 15 से 20,000 का. And on the other hand, the BMW would have required about, I'd say about a lakh, 1 lakh or odd rupees of raw material. Now, from the raw material to the finished product, the process of converting the glass, the rubber, the plastic, the alloy, all of these things into the finished products that you see is what is the intellect that is applied. So that process of conversion of the raw material into the finished product is what is called intellectual application. And therefore, the property that gets generated out of the application of that intellect is the property which is the Honda Activa or the BMW 1250 GS, which basically means Honda Activa में theoretically intellectual property कम है, BMW में intellectual property ज़्यादा है. Now, how am I saying कम है और ज़्यादा है? I'm saying कम है और ज़्यादा है in monetary terms. In terms of the application of technology, the kind of technology that is applied in the BMW is far more advanced than the technology that is there in a Honda Activa. For example, Honda Activa may very basic stopping mechanism आता है. पीछे में आता है what is referred to as a drum brake. A drum brake is a technology in which there is one drum inside another and the expansion of it stops the rear wheel from moving. Front में मेरे ख्याल से, if I remember correctly, they've got one small disc brake. The BMW, on the other hand, has very, very large disc brakes, dual disc brakes in front and a single disc brake at the back. Now, obviously, इसमें technology ज़्यादा लगी है, इसमें knowledge ज़्यादा लगा है, इसमें application of science ज़्यादा लगा है, and that's why I am saying the intellectual property which is there in a BMW is far more than the intellectual property that is there in a Honda. So, to sum it up, what is intellectual property? Intellectual property is any property that is created from the application of the human mind, which can be something as simple as this bottle of Bisleri water, which is sold with the brand name Vedika. Yeah, this is also intellectual property because किसी ने दिमाग लगाया है उस पानी को एक बोतल में पैकेज करने का, उस पैकेज करने के बाद उसको कलर कॉम्बिनेशन में डालने का, उस बॉटल को एक पर्टिकुलर शेप देने का. All of this is the application of the human mind with the intent to sell the product that you create through this application of human mind to the ultimate customer. So the next question that comes up, if intellectual property is any property created by the application of the human mind, the next question that comes up is, how is it different from other forms of property? Like, for example, land. Why is it different from land? Now, or other, it could be other forms of property also. The difference between physical property or property like land and intellectual property is land does not require intellect to create. Land exists. It's something that we have got from the earth and we have appropriated it through legislation, which basically means land, all land, for example, within the boundary of India belongs to the Indian government, and through the Indian government, we can own such property because they allow us as individuals, as citizens to own property. We are allowed to own property. For example, the land on which Symbiosis Arts and Commerce College is built, that is theoretically owned by the government, which has been allowed and given at a particular cost to Symbiosis to use for setting up an educational institution. So, but there was no intellectual property or intellectual application of mind from Symbiosis to create that land. It existed, it was given to Symbiosis, and Symbiosis bought it at a price. On the other hand, something like the name Symbiosis for an educational institution required somebody's, in all probability, Dr. Majumdar's intellect, and where we've got Symbiosis written in a particular font with Vasudhaiva Kutumbakam written below it. It is our logo, it is our motto. Now, this is somebody's intellectual input, where the idea of the world is one family is not something which Dr. Majumdar came up with. It is a Sanskrit idea, but the application of that idea to an educational setup where his vision of bringing all students from all over the world together is intellectual property, because he thought of applying an idea which existed to a given setup. So intellectual property in that sense can be appropriated legally from different sources and created together and applied in manners in which you decide to apply it. So intellectual property, therefore, is different in a physical form and in a virtual form. They've got different purposes, they've got different needs, and they've got different ideas that come out of intellectual property itself. So this is a very, very basic introduction to what intellectual property is and how is it different from other forms of property. Please remember a very basic difference between what is intellectual property and what is intellectual property rights. Intellectual property rights are the rights which get legally associated with the creation of intellectual property because of the existence of certain laws. Now, you would have heard of laws like copyright, trademark, design, geographical indications, patents. All of these words you may be familiar with. We'll go into a discussion of each of these words and try and understand what they mean. But the rights are created these rights are created through the application of certain laws which have been created in India to ensure protection in this field. So intellectual property rights are the application of such law, or the consequence of the application of such law. But you also must remember that there is a difference between what is intellectual property as opposed to what can be protected in India. Let me repeat myself. There's a difference between इंटेलेक्चुअल प्रॉपर्टी एज अ कॉन्सेप्ट क्या चीज है और उसे कानूनी तौर पर आप इंडिया में प्रोटेक्ट कर सकते हो कि नहीं. सो कैन यू प्रोटेक्ट दिस आइडिया इन इंडिया और नॉट? फॉर एग्जाम्पल, लेट मी गिव यू एन एग्जाम्पल. Something that there's a form of intellectual property which is very relevant in the United States of America, which is not applicable in India at all, called trade secrets. Now, one of the examples of a trade secret is the formula of Coca-Cola. How Coca-Cola is created, the secret ingredient formula is not known to anybody apart from 3 or 4 people in Coca-Cola itself, which is then through a very elaborate structure of information exchange given down to the execution, and then the product is finally created and given to you. This is protected under a law called the Trade Secret Law. This law, however, does not exist in India as a law. We don't have a law called Trade Secret Law. ऐसा हमारे पास कानून ही नहीं है. Although it's a form of intellectual property, the application of that intellectual property in India does not exist. So, for example, if you've got a secret way of manufacturing something, you will not be able to protect it under a trade secret law in India because that law in itself does not exist. What you will have to do is figure out a way to protect it under other forms of intellectual property. So there is a difference between what is intellectual property and what can be protected in India. You may find a situation where there are things that can be classified into intellectual property, but they may not warrant or they may not have protection in the Indian legislative setup. Now, you must also remember that intellectual property as an idea or intellectual property laws as an idea are restricted by territory, which basically means that even if you get protection for the intellectual property that you've created, after having created such property, it will still not be protected internationally. What does this mean? So, for example, if I create a technology for what example do I give you? Okay, let's take the simplest example I can come up with by looking at my own sordid face. If you come up with a technology for growing hair, and it's a technology that grows hair in 5 minutes, so you just have to, for example, you come up with a technology where you have to just apply something on your head and it creates root follicles in the scalp and it generates hair in 5 minutes. It'd be a scary product, but in any case, let's presume that you come up with a product like this and you apply for what is referred to as intellectual property protection under the law of patent in India, and you receive that patent. It will be protected only within what is geographically defined as India. Unless and until, so for example, somebody comes to India, sees this product, says, wow, this is amazing, takes this product, goes back to her or his own country and manufactures that product all over again. Unless and until you go and protect your rights in that other country. For example, that person's from Australia, manufactures it in Australia and starts selling it in Australia. Unless and until you go to Australia, register your patent there and enforce your rights of the patent in Australia, you won't be able to protect yourself. तो कोई वहां पे आपके अनुमति के बगैर वहां पे प्रोडक्ट को मैन्युफैक्चर कर सकता है और बेच सकता है, but you won't be able to sue that person because you have not registered the patent in that country. As far as that country is concerned, it is not a right that has been given to you. So anybody else can use that right. So please remember, intellectual property as a system, as a format, is protected by territory. So it is applicable to a territory and therefore must be protected in every territory that you want to exercise your rights in. Okay. The next thing that you need to remember about intellectual property is that the protection that is given is for a limited period of time. ये नहीं कि आपके पास इंटेलेक्चुअल प्रॉपर्टी अगर आ गया तो मतलब जिंदगी भर के लिए आपके पास इंटेलेक्चुअल प्रॉपर्टी उस प्रोडक्ट के ऊपर रहेगा. इट इज गिवन टू.
पालन करें. क्या आपका रिचार्ज हो गया है?
एक्सक्यूज मी.
के लिए कृपया दबाएं. आपको डिलीवर्ड होगी संबंधित.
Hello? Okay, so intellectual property can be protected only for a limited period of time. By that I mean, if you get protection for a particular form of intellectual property, it does not mean that forever you will be able to protect it. उदाहरण के तौर पर patent law, for example, if you get a patent, it is the period of protection available to you is 20 years. If you get a trademark, then that period of protection available to you is for 10 years, but which can be renewed for 10 years. So every intellectual property has a different form, different duration for which it can be protected. What you need to understand about intellectual property is that there is a difference between the basic concept of ownership and possession. Now, in physical property, you can own the property and you can possess the property also, and therefore laws have been created for protecting ownership and possession. Like, for example, trespass. If you say two forms of protecting physical property are theft and trespass. मूवेबल प्रॉपर्टी है तो उसके ऊपर थेफ्ट का कानून लगेगा. मूवेबल प्रॉपर्टी टेकन आउट ऑफ पोजेशन विदाउट परमिशन, you apply the concept of theft. You say that this is my property, you have taken it without my permission, and I will apply theft to you. One. Secondly, if it is immovable property, like the property that you own, which you are a part of at Symbiosis, there is a campus, there is a gate, there is a wall, and if somebody enters that gate without having a proper authenticated ID card or the permission of the authorities in place, then it is called an act of trespass where you've entered a property without permission. However, these laws were great at a time when property was very limited. It was either a physical property or where you owned a horse, a dog, a cat, which became your property, or a house or a land. These laws were easily applicable. But as soon as this law started to look at the protection of intellectual property, the scenario became very complicated and further became complicated when it became virtual. So first level of complication came in when you started protecting the outcome of the intellectual pursuit of human beings. First complication came up then. The second complication came up when you took this intellectual pursuit and you made it virtual. Now, instead of trying to protect possession, now, for example, in the virtual world, if I have, for example, created a software and I uploaded it onto a website, and I say that this is software that has been created by me, I have ownership on this software, but I have no possession of this software. Can you understand? I cannot physically hold the software. There is no possession. This is a concept which is related to the real world. Ownership and possession are concepts which are related to the real world. In the virtual world, however, you have ownership, but you don't have possession. And therefore, the laws need to be adapted further to be able to accommodate these technological changes which are coming about because of advancement of technology. What has transpired is we have now started using concepts rather than possession of access. So what the virtual world to protect intellectual property tries to restrict is access. For example, your video streaming services like Netflix or Amazon Prime Video or Hotstar. Now, what are they doing? They've got intellectual property on their platforms, like there are documentaries and movies and serials and all of this. If you want to watch their content, you need to be able to connect your email ID, your mobile phone, they will authenticate it. You have to pay a subscription fee, and then you have access to that database. So access to that database based on a subscription model where you pay a certain amount of money to access that content. Here, what you are doing is, through a system of authentication and username and passwords, you are restricting access of individuals to certain intellectually created content. This mostly fits into the category of copyright and trademark, and the technology used can be protected under patent. But there are forms of intellectual property which are protected in the digital space through access control mechanisms. In this case is authentication and username and password systems. But basically the idea is of access control. This is the transformation of the law that's taking place over a period of time. So ownership and possession also has gone through a sea of change when it comes to intellectual property. Now, the point that I was on prior to this was the idea of limited timeframes for which intellectual property is protected. The question that arises after this is, after intellectual property, the term for which the protection is available is over, what happens? अगर फॉर एग्जाम्पल आपके पास उदाहरण के तौर पर 20 साल के लिए आपके वो हेयर ग्रोथ whatever that serum was, उसके ऊपर आपको 20 साल का प्रोटेक्शन मिल रहा है, 20 साल के बाद क्या होता है? Any form of intellectual property, after it loses its protection, goes into an area called public domain. This is a word that you must remember. It's called public domain. Public domain का मतलब है everybody can own it. Anybody can own it, everybody can own it. जब तक इंटेलेक्चुअल प्रॉपर्टी कानून के दायरे के अंदर है, तब तक उसका ओनरशिप आधारित है, निर्धारित है. That basically means that, for example, as long as a technology or a particular work of art falls within the realm of intellectual property, just to take an example, J.K. Rowling's work, Harry Potter, or the various books that she came out with. All of these fall within the category of intellectual property, and for as long as the term of intellectual property remains, she will own the rights to this creation. However, as soon as the term expires, it will go into public domain. All right. Now, what do I mean when it goes, when works go into public domain, or which content of intellectual property goes into public domain? It means nobody owns it and anybody can use it. For example, the works created by Shakespeare. Shakespeare's works have gone out of the protection of intellectual property. I can, without asking anybody's permission, print Macbeth, Romeo and Juliet, any of the plays that were written by Shakespeare, and appropriate it. For example, one of the appropriations of Shakespeare's work which was done was this movie called Omkara. If you remember, there was it's a very well done movie. I think, as far as I remember, it was a recreation of Macbeth. The storyline had the characters were there was Saif Ali Khan, there was Ajay Devgan, there was Kareena Kapoor. I think there was Konkana Sen as well. Very, very well made movie, built around a theme and a story that was created by somebody else. But because the protection that was provided by intellectual property was over, it went into public domain and they could appropriate it and make it a story which actually happened in India, in some part of India. They adapted it and used it in India. So this can be done once the work goes into public domain. I need you to remember this word, public domain. By public domain, we mean everybody owns it, which basically means anybody can use it without asking really for permission or authority or anything like that. But you must also remember, even in public domain, the rights of the creator still, some of the rights of the creator still remain with the creator. We'll go into the details of it, but I want you to remember this. I cannot turn around and say that Romeo and Juliet was written by Gokul Narayan. I can't do that. The association of the creator with the content that was created will always remain, even if intellectual property or the term of intellectual property exhausts, you cannot appropriate that content as your own. So I will never be able to say that I wrote Othello or Macbeth or Romeo and Juliet or whichever play of it, or after the period of protection for J.K. Rowling's work finishes, my successors won't be able to say that they created it. It will always be J.K. Rowling's work. So this is something that you need to remember. The concept of public domain. Is there anything else that I want to tell you about intellectual property? In terms of the basic introduction to intellectual property, let me think if I missed out on anything. So I've told you that intellectual property is Malik. I'll just review and then I'll give you an. Thank you for raising your hand. Just give me 1 second. I'll just review it and then I'll give you a chance. So intellectual property is any property that is created by application of the human mind. It is protected within a geographical territory. Its concepts align both with ownership and possession, but in the virtual world, it goes into ownership and access. Intellectual property, there is a difference between what is protected under intellectual property in India and what falls into the category of intellectual property. What was the last point that we did? The idea of public domain. There is a limited period of protection provided for intellectual property. After it extinguishes, it goes into public domain. Yes, Malik, you had a question?
Good afternoon, sir.
Good afternoon.
So, in the beginning, we talked about the difference between the business trade secret, which is in foreign, and there is no such thing in India.
Correct.
And after that, we took the example of that hair oil, in which you said that if you have the secret of that form, if you have that oil and you don't file the patent in your host country and in other country if that is being made and manufactured, you cannot sue that.
Yes.
So if that person comes to the host country and files a patent, will that mean the stopping of the operations of that person who actually made that?
No. So since patent is a right which is given after scrutiny, after so you'll have to make the application to the patent office, Indian Patent Office के पास आप application देने जाओगे, उस application को scrutinize किया जाएगा, उसके बाद ही आपको patent दिया जाएगा. So even if that person comes back, that other person who didn't appropriated the property comes back and applies for a patent, they won't get it. We'll go into the details of how this works, but the question is very relevant because you already have an existing right in the form of a patent right. They will not be able to exercise these rights because these rights will be given to you as per law.
So why if Coca-Cola is registered under the business trade secret, which is a foreign law?
Correct.
Why is it applied in other countries when there is no such law?
It's not applied in other countries. So in India, there is no, if their trade secret gets out, they won't be able to sue anybody in India for that getting out. They are still keeping it a secret because of their processes that they have in place to ensure that the recipe is always kept safe. But if it gets out, they won't be able to sue anybody in India.
Like if why doesn't it come if it is present? If we have so many sales of Coca-Cola in India, India is a huge market for that.
Correct.
Why can't the government, as it is a consumption item, why it won't come under the food securities bill, something?
So it can be protected under patent law. Recipes can be protected. So India says that you don't need a trade secret law. If you look at most countries don't have trade secret laws. It's only the United States of America and a few other European countries which have. We don't require in the Indian context, we are saying that we don't require a trade secret law. There are other forms of intellectual property that can already protect such content. So you don't require it. That's our argument. Does that make sense, Malik?
Yes, sir. Yes.
Okay.
Thank you, sir.
You're welcome. Anybody else had questions? Whoever's raised their hands, please feel free to ask the question.
Okay. Up next, we have Aditi. You have raised your hand, so please go ahead.
Aditi, please go ahead.
Hello,
good afternoon, sir.
So actually my question is like when a particular intellectual property is protected for a certain period of time and after that when it gets over it goes into public domain. So
Yes.
actually this thing is applicable for all across the nation or like only for the country in which the patent has been created or the intellectual property has given the right.
Very, very good question. Now, it's a slightly complicated question, and therefore I'll have to go into certain details. But and I'll go into the details once we go into our discussion. But for now, um, as soon as the work, so it can't be possible that, for example, मैंने अगर आज intellectual property के लिए X time पे मैंने apply किया X जगह पे and Y time पे apply किया Y जगह पे, so the time period will be calculated from the time at which the application was made in that particular country. Okay, so what generally people try and do is they try and make applications all over at the same time so that the right can be enforced at the same time everywhere. What I'm trying to say, Aditi, over here is technology and rights basically have very limited time periods within which they can be exploited. Therefore, it is imperative that you start getting commercial use of the content that you've created as soon as possible. So basically, the nutshell answer to your question is that if you make an application in a particular country for the protection of intellectual property, once it extinguishes, you cannot protect it. And therefore, in another country also, you will not be able to enforce those rights. Does that make sense, Aditi?
So yes, sir.
Okay. Who had the next question?
Yeah, hello, sir.
Next, we have Niranjan.
Yeah, Niranjan.
Yeah, good afternoon, sir.
Good
So
afternoon.
you told us how the protection period is renewable when we're talking about intellectual property rights.
Some are renewable, some are not. So there is no standard application. For example, copyright cannot be renewed, patent cannot be renewed, trademarks can be renewed.
Okay, right. So what I wanted to ask is that before the like, let's take an example of a trademark. Let's say before a trademark is renewed, is there a certain window when it is still in protection? Because it only takes like a second to copy these things, right?
Yeah, I'm unable to understand your question. So is there a window where there is in protection? What do you mean by
Is
that?
there a window under which the said owner can renew its protection and after before it enters the public domain?
Yes, yes, absolutely. Very good question again, Niranjan. Yes, absolutely. In trademark also, there is a window of protection. So even if your trademark has expired, for example, आपके 10 साल खत्म हो गए हैं, आपको फिर भी एक window of opportunity दिया जाएगा where generally you receive a trademark notice saying that your trademark has expired. If within that extended it's a small, I think if I'm not wrong, it's a 45-day period. If you do not renew your trademark within that period, then it will go into public domain.
Yeah, and
Yeah.
and in addition to that, I had another question.
Please go ahead.
Yeah, so this was regarding NFTs, non-fungible tokens.
Yeah.
So there's a process called minting where authenticity certificates are created for NFTs, and these authenticity certificates prove that the NFT in question is the original work or is an original property. So is that enough to protect the owner of said property, or does IPR play any role here as well?
So IPR, very good question, Niranjan. Intellectual property is merely a set of laws in place to protect the rights of individuals who have created content. All right. So an NFT, a non-fungible token, is the application in this context is the application of blockchain technology to protection of rights of individuals who have created content. So over here, what you are trying to do is, for example, in the real world, if you've got some creation which was made by Vincent van Gogh, there's a physicality to it, and therefore, through an art house who authenticates the artwork, you can turn around and say, I have an original of that content.
Okay.
However, in the digital space, it is without the existence of a blockchain or a ledger-based system technology, which is based on cryptography, it is impossible for people to say that this is the original work and I am the owner of it. For that purpose, you are applying a particular set of technologies for protecting the digital version of that content. Okay, so now when you've applied technology to protect that content, after you have authenticated it, the various intellectual property laws come into force to protect that authentication. Now that you've said that this is an original work created by X person, intellectual property law in the form of, for example, copyright will come into force and say, okay, now we are protecting this original work because it is being classified as original. Okay. So a copyright or trademark or patent in itself does not authenticate, it gives protection to that which has been created. The process of creation, the process of authentication will be through the work of the digital creator and the application of technology in the form of blockchain and non-fungible tokens to such creation. I don't know if my answer was too complicated. I mean,
No, sir, I got what you said, what you were saying. Yeah.
You got okay.
Thank you so much, sir.
You're welcome. Next.
After Niranjan, we have Tahir.
Tahir, go ahead, Tahir.
Good afternoon, sir. Sir, my question is right now, as Niranjan questioned about NFTs and the artworks. So my question basically is, when an artist creates something unique of itself, like it may be a song, it may be a artwork or anything, how does intellectual property apply in that context? If it is not patented or because when you just create an art, you just go on creating an art, means any artwork. You can't be patenting each and every artwork you create. So how does that thing get protected in the real world?
Just give me a second. I'm getting a call. I'm going to reject that call. Yeah. So Tahir, your question's very relevant, but may I answer it once I go into the forms of intellectual property? It's a very, very relevant question, but it may be that we're one step ahead because I've not discussed the forms of intellectual property. As soon as I discuss the forms of intellectual property, I intend to go into this very question. Can you remind me in just a little bit of your question, please?
Yes, sir, sure.
Yeah, thank you so much. I'm not answering it over here for a particular reason, and you'll understand it once we go into the details, but it's a very relevant and good question. Thank you.
Yes, yes.
Any other questions?
Up next, we have Nikhat. I hope I'm pronouncing your name right.
Yeah, good afternoon, sir. My question was, so basically you said that intellectual property is guarded by, like you get intellectual property territory wise, right?
Correct.
So suppose I have an intellectual property here in India, and in Australia I can't fight for those rights if somebody else already has the patent for it.
Yes and no. So like I said, if I've applied for a patent in India, my rights can be protected in India. If I want to protect my rights in Australia, I have to separately go there and apply for those rights and then protect them there. However, to overcome this problem, we've got something known as the Patent Cooperation Treaty, which provides a multi-window application to numerous countries at the same time. So while applying to India, I can apply to Australia, United States of America, France, the entire European Union, the entire African continent. I can decide which countries. I can pick and choose from a basket of signatory countries, and I can apply to all of those countries together. Does that make sense?
And sir, are the territories only limited to countries or like state-wise also? Like suppose there's a small business in Maharashtra and they want to patent their product or their intellectual property only in that certain area. So the government decides which territory the patent is applicable to?
National applications. Very good.
National application.
Nika, very good question. It's national applicability, not state-wise applicability.
So the only territory bound is the country.
Correct.
And when you apply, and if a fashion house, suppose there's a fashion house, they have their own designs and everything, and they also ship internationally. So because their intellectual property is their design, but they don't have a patent or like copyright in other countries. So that's okay, right? Even if they ship internationally and somebody else copies it, they have no say in it. Like they can't fight for
protect their they won't be able to protect their creation. Yes.
Okay, sir. Thank you. That's all.
Next. But Nikat, I will be giving certain clarifications and you'll figure it out as we have a conversation. You'll figure it out. I will give certain clarifications to make this idea a little more clear.
Yes.
Okay. Yes, go ahead. Next.
Okay. Next we have Mallar. So, Mallar, please go ahead.
It was a great session. Can you hear me?
Yes. Yes,
okay.
Mallar, please go ahead.
So I had dual questions, but I think one of those questions you had answered, like we have a global framework for if you want to apply for an IPR that is applied on a global basis and in different countries. So I'm going to ask you two other questions that I had in my mind. The first is, for a long time we have seen that even though India has strong legal frameworks for IPR, the place where it's lacking is the enforcement, right?
Absolutely.
And what do you think? What do you think is the current situation of that in India? And do you think that is one of the deterrents as to why our homemade startups are now going to, for example, Byju's have gone to the United States to set up their headquarters. So do you think one of the reasons for that is the poor law enforcement for IPR in India? And the second question is, for the last couple of years, one of the greatest threats to the United States has been a country like China, which is basically stealing their IPR. And, that has been one of the biggest concerns if you look at geopolitically for the United States. So how do you think the world can try and figure out a solution to that?
Mallar, very good questions. I mean, I'm forced to think about the answer, which is great. Thank you so much for asking them. Let me try and say it like this. First of all, I do not see the concept of intellectual property itself is very maligned. Let me ask all of you this question before I answer Mallar's question, because it's such a great question. I'm forced to ask this of all of you. Can you think of anything that you have created in your life, anything that you've created in your life, which has been created completely and absolutely out of your own intellect without getting influenced by anything that you have seen, read, heard, talked about, viewed before? So think about anything that you've created that you're proud of, that you don't even need to be proud of it, anything that you've created, but has nothing to do with anything that you have seen, read, heard about, or discussed with a friend. Anything. Can anybody come up with anything? Like, could be a photograph, the idea of the composition of a photograph that you've seen, but the composition idea may have come from somewhere else. The work of art may have been influenced by other things. The basic, and I want you to think about this question. Human beings as a species work on the idea of copying. We work on the idea of, how do I say, the difference between, and this is a very big debate, the difference between at what stage does inspirational work end and at what stage does copying begin? A very big debate. आप इंस्पायर्ड हो किसी और के काम से और आपने किसी और का काम कॉपी किया है. This legally has been a bane for legislators and judges and law forums to discuss and decide how and when this entire concept can be disassociated, where you can clearly say that this is an inspirational work, which is great, and it is because human beings work only on inspiration. For example, Bernard de Chartres had once upon a time said that it is only we can look forward by standing on the shoulders of giants, which basically means we cannot do anything without being inspired by that which has come before us. There would be, if you look at technology, there would be no, how do I say this, Boeing A380 or A380 without the Wright brothers being in place, without learning from what the Wright brothers did. And theoretically, even the Wright brothers did not have a technology patent on the aircraft. They had vertical lift, sustained vertical controlled lift is what they had a patent for. And to throw things into perspective, one of the greatest innovators in today's day and age is supposed to be Apple. They started off, Apple, and I'd say along with Google, I put 3 or 4 companies in the same genre, whatever you want to say. Google, Apple, Microsoft. I don't want to consider Sun Microsystems and IBM and all of that, but in the technology sphere, I'd put maybe these 3 as the giants. But if you look at it, most of the initial work that these guys came up with, Apple came up with, or for example, Microsoft came up with, was all copied work when they started off. For example, when IBM approached, so when Bill Gates approached IBM saying that you are a hardware giant, I'm going to give you software which is applicable to your computers, the hardwares that you're creating for the computers, you're creating the infrastructure for the computer. I'm going to create something which will be very seamlessly applicable to your hardware, and you can sell the 2 together. IBM thought the future of technology is going to be in hardware. Bill Gates and Steve Wozniacki thought that the future of it is going to be in actually, Steve Jobs, Steve Wozniacki, all of these guys had a different approach from what IBM did. Apple went the route of combining hardware and software together, and Microsoft went completely software. But at the time when they struck that most important deal with IBM and sold them what was known as the disk operating system, which later on went on to become the MS-DOS, the Microsoft Disk Operating System. At the time when they made this deal, when Bill Gates made this deal, he did 2 very intelligent things. One, shockingly, at the time when he made this deal, he signed the contract with IBM. He did not have this software. They had not created anything like this. They did not have anything like this. 1. 2. He also took rights from IBM saying that I should be able to sell this to whoever else I want to. It will not be exclusive to IBM. All right. So he said, I'm not going to make it exclusive. Then he sends Steve Wozniacki to an Atlanta-based technology organization where he buys their disk operating system because he's seen it at a convention. He buys it from them, absolute. He pays them some $50,000 or something like that. Because of the money that he got from IBM, he gave it to that guy. He gave him a pittance of what he had received. Very, very small amount, gave it to this guy, picked up the software from the Atlanta-based company, struck an exclusive deal with him, saying that you have lost all rights over this software. This now completely and absolutely belongs to me. You have no rights over this software. You cannot use this software. You cannot do anything with it. But when he himself went to IBM, he said, I'm not going to make it exclusive for you. I retain the right to give it to anybody else. So if you look at the entire idea of misappropriation of content and intellectual property, the word hacker actually began with organizations like Apple and Microsoft hacking into or breaking down systems which were established by major players. What did Apple do on the other hand? Apple, on the other hand, took all the innovations that were created starting from the cursor, the arrow that points towards things, the cursor, the trash box, the intuitive trash box, to delete contents, you just put it into a trash box, the folder icons, all of these things were innovations that Apple never came up with. They took it for free from you know who? From Xerox. The now manufacturer of photocopying machines were at the forefront of technological computer development back in the day. They took it for free. They said, Lelo, they didn't charge them for it, but Apple charges everybody for everything that they create. Therefore, my idea, Malhar, is a little confused. I myself am confused, and I'll tell you why. Because the organizations which shout out the loudest saying that our intellectual property has been stolen by X and Y and Z and they are making money out of what we have created, never created the initial products themselves and never shared with the people who they took the money from. So it's never that Steve Wozniacki or Bill Gates or Steve Jobs went back to the organizations that they made the money from and took the technology from and saying, we have made a lot of profit based on what you've given us. Here, share the profits with us. Nobody did it. They appropriated the profits for themselves. And this is the form of intellectual property. So I find it rather hypocritical when these organizations say that other people are stealing our technology, because the innovation systems that have been put in place have come into place because of these technological giants influencing legislation to suit them. Now, I know, Malhar, this is a slightly complicated answer to your question, but it was such a beautiful question. I need to go into certain details. How do I say this? All right, the Hitler, the Mussolini, and Ivan the Horrible, and whoever, Genghis Khan of the technological world, sorry, of the pharmaceutical world, is this organization called Monsanto. Right? It's like everything in my head, everything evil that can be thought of, all rolled into one. Now these, okay, let me not go into the Monsanto example before I explain to you what patents is. But my basic point, Malhar, being intellectual property has been created to promote the rights of individuals. Here, I'll try to introduce you to a concept, all of you. It's called quid pro quo. Could somebody type it out on the chat? Where is the chat? Let me type it out.
It is something in return, right? Something in return for something.
Yeah. So it's a Latin term which means you scratch my back, I scratch your back. So it's like a give and take. You're absolutely right, Malhar. So the quid pro quo concept basically acknowledges the fact that creators and legislative bodies have to gain from each other. Technological development is something that organizations and governments want happen in countries. To promote science, to promote technology, they say that we will give you protection from other individuals and other people who will try to copy your content. So what are we going to do? You create the content. So they're promoting artists and authors and innovators and creators to go ahead and explore their creative output and create content. In exchange, what are they giving them? You say, you create this and you reveal it to the world. Let everybody take advantage of it. But what we will give you in return is two things. One, a legalized system of artificial monopoly created for a limited period of time, which basically means अगर आपने कोई चीज क्रिएट करी है तो एक लिमिटेड पीरियड ऑफ टाइम पे के लिए हम सिर्फ आपको परमिशन देंगे उस कंटेंट को कमर्शियली एक्सप्लॉइट करने का. So we will legally create an artificial monopoly or an artificial monopoly mechanism within which you can control demand and supply, because this is at the end of the day economics. If there is more demand, less supply, I will be able to benefit from the cost manipulation. All right, I can charge more because there is less available, and I can control that mechanism. So what does the government do? Through a legislative process, creates an artificial monopoly wherein you can exploit that creation for a limited period of time. Secondly, during this time, if somebody else tries to appropriate that content and use it without your permission, the law also gives you a guarantee of protection, right? Now, the problem comes in when organizations become so powerful that they are able to manipulate legislative systems to create legislations to suit their own capitalistic needs. For example, patenting of mathematics. All right, Malhan, or anybody, Manish, just remember to remind me when I do patents, I'll give you the example of patenting of mathematics to be able to explain the exploitative nature of intellectual property also. It is
Sure, sir.
capitalism in its most extreme and most vulgar form. It's the idea of intellectual property was to promote development. But if this development happens only for some people who are commercially well off, then it's not for the benefit of all. And that's where the downside of intellectual property comes in. And in that context, I'm very happy that there are balancing factors like countries like China and India, wherein there is a, a basically equalization of intellectual property also because of piracy. I think piracy is bad, but if in an extreme vulgar form of capitalism, piracy comes as a opportunity to neutralize the playing field. Otherwise, it becomes a situation where technology becomes accessible only to the uber rich. And that's not favorable for the world at large to develop. So that's why I'm a little conflicted about it. And that's why this very long, convoluted answer to Malha's very, very
Sir, I
intellectually
think
stimulating
sir,
question.
you have answered my question because I think one of the points you said was something that I was also kind of coming at, which is, you have tech giants like Microsoft and Google spending millions in lobbying every day in Washington and in other countries. So it's going to be difficult for anybody like who is just starting out to compete with
Correct.
them. And I
Correct.
think it has been there for very beginning. Like even if you remember Edison and Tesla,
Yeah,
Tesla
yeah,
was a real inventor, and then
absolutely.
Edison used to take his inventions and commercialize it. So yeah, I think it
Absolutely.
has existed for
Yeah, you're
yeah.
absolutely right. Um, So, any other questions, or should I continue with the rest of it? Because I know you've got questions. I can keep going on, but let me just finish a little part of the differentiation because there were certain terms that all of you used which were a little overlapping, and I'd like to just provide some clarity before we move on, so that you're clear about what we are talking about, and these terms become more compartmentalized for you. So if I can provide that clarity, then we can start off the questions all over again. No worries. Do you mind if I do that?
No, sir, no problem with that.
Oh, okay, okay. But thank you so much for asking questions so enthusiastically. It makes my entire conversation so much more of a pleasure to have. See, unfortunately, please have some empathy for your teachers. The reason why all of us faculty members became teachers in the first place is because as we grow older, uh, our our enthusiasm comes from interacting with the younger generation. And you will face this when you grow older as well. Interacting with the younger generation is one of the, I can take energy from you, I can take passion from you, because you're not adulterated with all that's happened with life, because your minds are fresh. The biggest problem that this pandemic has created is that I am looking at a screen, looking at my own face and speaking. And it takes the fun out of interaction because I can't see your faces. I can't see your reactions. I can't see what your mind. So your facial expressions when I'm sitting in class reveal to me what you're thinking. And I know some people are confused. I know some people are thinking, some people have figured it out, and it makes the entire um, experience of teaching a wonderful experience. Unfortunately, COVID has taken or robbed us faculty of that joy of interacting with all of you. But Thank you so much for asking questions, because it makes my job of speaking a lot more pleasurable. But having said that, before I get more emotional about this idea, let me say this. There are forms of intellectual property, and I will talk specifically about a few forms. 1, copyright. 2, patent. 3, trademark. 4, geographical indication. And 5, designs. Since all of you have spoken about all of these things in varied, accidentally spoken about all of them, I'll speak about these 5 things, and I'm going to repeat myself. Copyright, trademark, patent, geographical indications, and designs. Now, let's begin with the most familiar, which is copyright. Now, what you need to remember about copyright is copyright applies only to literary, artistic, cinematographic, films, and sound recordings. So all kinds of artistic work, whether it be somebody writing a poem or it be an individual clicking a photograph, all of this forms the realm of work which is covered under copyright. Now, copyright, so what does it cover? Literary work, artistic work, cinematographic films, sound recordings, photographs. It also covers the domain of computer software. There is a little bit of an anomaly over here, but I will clarify that as we move along. However, what you need to remember about copyright, and this is what is peculiar about copyright, and all your questions brought these ideas out. Copyright as a form of intellectual property need not be applied for. इसका मतलब क्या है? आपके पास कोई जरूरत नहीं है किसी ऑर्गेनाइजेशन के पास जाके दरखास्त करने की कि मुझे कॉपीराइट दे दें, ये मैंने बनाया है, इस पे मुझे कॉपीराइट दे दें. Copyright inherently exists in every work. So as soon as so for example, let me just wait for a second, please. Let me just change this because it becomes a little difficult to. I'm going to remove all this background effect and all this nonsense. One second. All right. So for example, I create this. Second. Just give me a second. I'm going to put my class 3 drawing skills to work. This is as much I know about drawing. You'll see that I'm rather artistically challenged. All right, so I have created a work of art, and I'm being sarcastic when I say that, but this work of art that I have created, all right, the sun, this is the basic drawing. If I ask all of you to draw a sunset, about 80% of you are going to end up drawing this. All right, not this. I'm sure your versions of this would be far better and look much better than what I have created. But this work is already copyrighted. I need not apply for a copyright over here. I don't need to go to the Indian Copyright Office and say, I want a copyright on this work of art. It inherently exists in a work as soon as the creator decides that it exists. अब ये complete हो गया. मेरे पास इसके लिए copyright already है. मुझे apply करने की जरूरत नहीं है. Now, there is a difference between needing to apply for a copyright, which is not mandatory, but protecting this. Now, if I want to protect this right, it will be more convenient for me to register the copyright. So copyright registration is recommended, not mandatory. Copyright exists in works of art and it exists in literary, artistic, dramatic works. What is protected under copyright is the expression of a thought. For example, let's take love as an idea. The love between two people. Right? And I'm talking more in terms of romantic sexual love. Right? I'm not talking about a love for a. In this example, I'm not talking about the love of a mother for a child, for example. I'm not talking about that kind of love. I'm talking more in terms of amorous love or romantic or sexual love. Now, this love, this idea of love can be expressed in various forms. For example, the song, what is that song? Raja ko Rani se pyar ho gaya. It's a, that's also, actually, that does remind me. Raja ko Rani se pyar ho gaya is the expression of Anu Malik. Saying that, singing a song for Amir Khan and Manisha Koirala, where he's saying that I fell in love with you the first time I saw you, blah, 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 blah. That is an expression of love. However, another expression of love is also Munni Badnaam Hui. That is also an expression of love, but that's more sexual, that's more raw. So what copyright protects is the expression of an idea. How you express that idea is what is protected under copyright law. The work under copyright law must be an original work. It should be original work. So let me just do an overview of what we've discussed under copyright. Literary, artistic, dramatic, cinematographic film, sound recordings, photographs, and computer software. That's the realm of copyright. Copyright need not be specifically registered. However, it is recommended but not mandatory. Copyright protects what? Expression of an idea, and that the expression must be original. Right? One. Second, we move into a realm called patents. All right. Patent law protects technological developments. All right. Innovations, changes in technology, improvements in technology, which have been created by the application of the human mind, are protected under patent law. So, for example, if you look at this is a slightly old development, but I'll just share that with you. When so air superiority in terms of combat power is something that most developed nations keep trying to achieve. That deterrent theory, if I've got bigger guns and more, you know that the nuclear threat is reduced now. So we've gone back from the era, I wouldn't say completely gone back, but the threat of nuclear war, because everybody has, I mean, a lot of countries have nuclear weapons. Now to use a nuclear weapon is not something that anybody is interested in doing, because there will be no solution. It will just wipe out the entire earth. So now what we are going back to the era of tanks and planes and unmanned aerial vehicles and so on and so forth. Now, the Russians and the Americans have always been at loggerheads since the Cold War to develop more and more systems of air superiority. Now, one of the innovations that the Russians came out with, which is still being explored, was typically an aircraft is like this. So it's got a center part and it's like this, and that's the shape of the aircraft. Now the Russians came up with what is known as the front swept wings. So aircraft ऐसा है, उसका tail ऐसा है, लेकिन उसके सामने के wings, instead of being straight like there are in commercial liners, and like this in fighter aircrafts or capable of moving in fighter aircrafts, this had wings that were like this, front swept wings. Now they're saying that the front swept wings make it far more agile, but this is still up for debate because aerodynamically I don't think it makes sense. But front swept wings are a technology that is being explored. So what are you talking about? An improvement in existing technology. Wings तो already हैं. You've got the concept of ailerons. An aileron is, सोच लीजिए wing है, इसके ऊपर एक पीछे का पार्ट होता है which is called an aileron. अगर आपको लैंड करना है तो ये ऊपर हो जाएगा और अगर आपको टेक ऑफ करना है तो ये नीचे हो जाएगा. सो बेसिकली अगर ऐसे जा रहा है एयरक्राफ्ट और ये aileron moves down, the wind will start hitting here and therefore the thrust that creates will also create lift along with it. तो वो ऐसे करके उड़ जाएगा और अगर जब उसको लैंडिंग का टाइम आएगा तो वो aileron ऊपर हो जाएगा, wind will hit here, it will automatically, because of the thrust that the engine is providing, tip the nose of the aircraft downward. Basic technology in flight. But innovations that happen in terms of how to make it more effective. Like, for example, the Airbus came up with a technology known as shark fin. I think you'll see it on Indigo's planes. So they've got a shark fin. So instead of having straight wings like this, they've got wings which has a shark fin on the side. ऐसे करके होता है वो. It apparently increases fuel efficiency, it increases top speed capability and so on and so forth. It's an innovation. All of these are changes which have been brought about in technology to improve the existing technology and make life better. It can be patented. Gorilla Glass, for example, which it's a patented technology which is now used in mobile phones. It's an adaptation of bulletproof glass, which was developed for protecting individuals from shrapnel and bullets and bombs and so on and so forth. Gorilla Glass came up from there. Application of technology for convenience. Now, patent, therefore, is technological inventions created with the idea of making life more easy. Patents, however, protect the idea. All right. What is the idea? As long as you can protect the idea, you can protect it under patent law. And one of the requirements of patent law is that that idea must be novel. Novel से मतलब है नया होना चाहिए वो. पुराना idea आप लाके protect नहीं कर सकते. This brings us to the question that one of your colleagues had asked. I think Nikhat had asked. I think so. I don't remember. But technology always has to be new. अब इससे मतलब क्या है? Let me give you an example to try and explain this and why I hate this uber capitalistic system of profiteering. Way back in the 1990s, and in fact, there's this person called Vandana Shiva. She, in fact, I was fortunate enough to see her because the Arts and Commerce College had called her. Dr. Soman had invited Vandana Shivaji some time back, quite a few years back, when I think all of you would have been in, I think in primary school or something like that. At that point in time, she'd come on. She's one of the greatest intellectual property rights spokesmen and patent law spokesmen that India has had. Now, what was her contribution and why is it relevant to our discussion right now? Patent law protects technological advancement. One of the requirement of patent law is novelty, that means your idea must be new. However, I did also tell you that intellectual property is protected only in territory. So, matlab, if you apply for a patent in India, it can be protected only in India. What a lot of pharmaceutical industries in America, in the United States of America specifically, and I don't mean any other North American or South American country, I mean the United States of America, started doing was appropriating traditional knowledge from other countries and patenting their content to profiteer. For example, one of the things that they did was applied for a patent for wound healing capability of haldi. They said that we have discovered, we have invented. They said they invented a technology by which the topical, which basically means surface application of haldi along with a few compounds to surface wounds helps in healing, and therefore they wanted to patent haldi. They also said that it is an antibacterial and so any kind of fissures, cuts, bleeds, burns, all of them can be treated through topical application of haldi. And it is also an immunity booster. So they patented it. They applied for a patent. They got the patent. अब इसका मतलब क्या है? Once you get a patent, it means that you can restrict anybody else from using what you have patented without your permission, which would basically have meant that they would become the only organization that could sell haldi in the United States of America. So our Indian diaspora living in haldi could not have taken packets of MDH from India and used it over there because a patent violation ho jayega. Vandana Shiva filed an objection saying that this is not novel. This is not new. There is nothing new about this. We have been using, in fact, the Rig Veda mentions about the use of haldi for wound healing purpose. And they took out documents from the yesteryears, Manusmriti mein bhi likha hua hai, and they took out Indian medical journals from the 1920s and journals prior to that also, because getting historical proof was a little difficult, but they found historical proof, enough historical proof. And they established the fact that this is not patentable because it's not novel. It's not new. You are using something that already exists and you are trying to patent that technology without permission. So one of the primary requirements of patentability is that that idea should not have been known before. Now, out of these cases, and these cases happened not just with haldi, it happened with jamun, it happened with Patanjali's Yoga Shastra, it happened with literally anything that you could find which was useful in traditional medicine or so Unani, all of this appropriated and created over there as pills and marketed as pharmaceutical inventions which will revolutionize the world. And they've done it not just with India, they've done it with all over the world. They've gone literally everywhere and done it. Now, the solution to this problem, and this is where India was at the forefront of technological development when it came to protection of rights of indigenous communities. We came up with a solution wherein we said, if novelty is a requirement, novelty cannot be, or newness cannot be a territorial requirement. It cannot be just new to India, to United States of America. Just because you are not technologically developed enough to know that this kind of technologies exist in your country, that does not mean that it's something that you can patent. So we came up with a solution called the Traditional Knowledge Digital Library, or the TKDL, wherein we started appropriating information from all over the world, creating a database of such traditional knowledge, which was helpful, accumulating it into a database, and then forcing all all countries who were signatories to conventions to use this database to test novelty. Now, what has happened because of all of this innovation that the Indian system has forced upon the international regime is novelty or newness. Although patent is a territorial right, the test for novelty is a global test. वो पहले नहीं होता था, पहले सिर्फ अपने कंट्री में वो चेक करते थे ये हमारे लिए नया है या नहीं है, अगर हमारे लिए नया है तो हम दे देंगे इस पे पेटेंट. लेकिन अब हमारे कंट्रीब्यूशन की वजह से of stalwarts like Vandana Shiva, what has happened is the test for novelty has become international, which basically means even if you are applying for a patent in the United States of America, they will test whether it exists as an idea which has been implemented anywhere in the world. So even if in some remote destination like Tuvalu, the island nation of Tuvalu, you have you see the application of that technology, it will not be granted in the United States of America. Although the patent is being applied only in USA, it will not be granted there if it is known anywhere in the world. So please remember, test of novelty is a global test, even though the application of that law is territorial. I hope I'm making sense. So patent for scientific and technological developments it protects ideas. These ideas must be new and novel. Okay, as long as you remember this idea and this concept, we should be fine.
Yes, I have a question.
Yes, go ahead.
So I know you've shifted to patent, but I had a question about copyright.
Please
So
go
you
ahead.
said that copyright is something that's created the moment any piece of work is produced, right?
Correct.
So what if someone replicates what you're making, like while you're making it? Say someone hears the song you're making and then they replicate it,
Yeah.
and then they claim it's theirs. Who will win that legal battle?
It'll be very difficult. So, Elena, it's a very, very good question, because this is exactly what happens in all over in copyright, especially in the music industry. Like, for example, there's a movie that came out recently. It's a Malayalam movie called Angamali Diaries. Now, certain parts of Kerala are covered by estates. Now, there's an actor called Prithvi Raj. While he was traveling in his car with a producer of a movie, they heard this old lady singing a traditional folk song, which is one of these communities which basically herd animals and sheep and all that. That's what they do. And they heard this woman singing a song. And they loved the tune. They loved her very raw, rustic kind of voice. But what they did was they stopped, they heard it, they loved it, and they made it a part of the movie. However, they did was they shared a large chunk of the revenue generated through that song with her, instead of appropriating that song. However, what very often happens is Bollywood especially does not share what they have appropriated from traditional culture, whether it be Rajasthani folk culture or mostly they steal from Rajasthani folk culture and Orissa, West Bengal, Kashmir, any place which has a lot of influence of music. Bollywood very often appropriates, and I'll give you an example of such misappropriation. And we'll go into the details of this and how this happens tomorrow. But since you've asked the question, one of the examples of this is this song called it's a song by this guy called Baksha. Hi, Bharat. Yeah, it's a song by this guy called Baksha. It's a song. It's a song which has Jacqueline Fernandez in it. What is the name of that song? I keep forgetting.
Is it Genda Fool?
Genda Fool. So the first part of the song has got a Bengali verse, a verse in Bangla, which has been said, Bodo Loker Beti or Lomba Lomba Chul. That's the words. This part was actually created and sung by a traditional folk artist, and he put it up online. Bollywood picked up that thing. These people picked up that thing, and then they appropriated it and made it a part of this thing, and it became a super duper hit and shared nothing with the original creator. That's why, Elena, the suggestion that is made by the Copyright Office is, although not required or mandatory to be able to effectively protect your rights, it is suggested that you register your copyright to make it more effective. Have I answered your question?
Yes, sir. But then, so what if you have like a date of making to prove that you were the original creator? Does that do anything?
It would make it easier. Establishing your right with respect to the creation would become a little easier. Yes.
So since that original singer's work was online, he could have used it as a way to say that this is my.
No, it wasn't online. It wasn't online. These people had heard it somewhere. So, see, folk artists generally don't document their content and then write it, because appropriation and misappropriation was not so serious back in the day. People just did what they had to, and then nobody created a hullabaloo about who owns it and who doesn't own it. And this is a very recent this thing where commercialization, where we have now started behaving like the Americans and started commercializing everything and started saying ye mera hai, tum nahi kar sakte, tum nahi le sakte, tum usko use nahi kar sakte mere permission ke bina, everything, all of this. It's the ownership was, the concept of ownership was very different, because we were a culture which believed in the idea of what do you say, sharing and learning through cooperation. If you look at any of the work that most of these renowned artists have done, all of them have been inspired by other works. But of late, we are becoming a culture which is more going towards the American culture of suing before asking. Pehle case file kar do, uske baad dekhenge hota kya hai. So establishing of rights and therefore of folk artists becomes something that copyright agencies and societies are trying to work towards. It's a process. It will take some time, because see, please understand, you as students of a very well-renowned college are getting access to information that tells you what and how intellectual property can be applied. But the average person on the street who's A, does not have access to such knowledge, and B, does not even know that this kind of information is relevant, and her or his talent only remains in creating that content, will not be able to protect themselves against a contract-based commercial organization which is doing this on a daily basis. So it's a difficult space that we find intellectual property in the world over, wherein commercial exploitation of rights is happening left, right, and center. So if you see, most of the narrative that I'm spewing in your direction is a very capitalistic, because I detest this capitalistic approach towards intellectual property, or the extreme capitalistic approach towards intellectual property that is being perpetuated nowadays. So unfortunately, my views on this are very strong, and they're very extreme, because we are moving towards a culture like the American culture, where we are not sharing, we are not cooperating, we are not becoming cohesive units towards development, but becoming individualistic and becoming more and more capitalistic in our approach towards generation of profit. Yes. Anybody else had a question?
4923 Ketul, you have a question?
Hello, sir.
Yeah.
So I have a question that we have a territorial patent, right? So if I want to go for a global patent, so is there any organization for it, or I have to go in specific countries and apply for patent?
You'll have to apply through specific countries, but there is a cooperation between countries, which is called the Patent Cooperation Treaty, which gives what is referred to as a single window application process to apply your patent in multiple countries. So it makes the process of application, आपको apply तो करना पड़ेगा, but through a single window application process, आप एक process के through सारे countries में apply एक time पे कर पाओगे, लेकिन register तो आपको सारे countries में करना पड़ेगा individually.
Thank you, sir.
Yeah, welcome. May I very quickly just finish the rest of it, so that then we can start off the questions? So I've given you an idea about patent and copyright. I know there are other people who wanted to ask questions. I'm so sorry. I'll quickly finish the rest of the forms of intellectual property that I wanted to introduce you to, and then we will come back to the questions, and I'm here for after that. So the next form of intellectual property that I want to introduce to you is trademark. Now, trademark is generally people associate trademark with the idea of quality.
Excuse me, sir. I'm so sorry to interrupt.
Yes,
So
yes.
you asked me to remind you about patenting of mathematics.
Oh yeah, thank you. Now, another wild side of the capitalistic system is this attempt in the United States of America, successful attempt I must add, to patent things like mathematics. Mathematics, according to me, is not an invention. Please remember, in patent, you can protect only inventions, not discoveries. If you've discovered something, for example, you've discovered gravity, you can't patent it. मैंने बनाया है, gravity मेरा है. Gravity is something that exists in nature. You may have, your brain may have expanded to accommodate the concept of gravity, but that does not mean it did not exist before you acknowledged it. Mathematics is like that. 2 into 2 equal to 4, nobody created. It always existed. Mathematics always existed in nature. Pythagoras theorem. So the square of the shorter two sides of the of a right angle triangle is equal to the square of the hypotenuse. This is not something that Pythagoras, the mathematician, created. He realized when he looked at right angle triangles and he joined the dots, he realized, array, iska square plus iska square is always equal to iska square. Now, mathematics, therefore, is always a process of discovery. Advanced mathematics is more and more discovery. We're realizing things. We are not inventing mathematics. The attempt being made in the United States of America is to patent mathematics. Can you imagine a day and age where somebody tries to turn around and say, I'm oversimplifying the concept, but a plus b whole square is mine. You can't use it because I own it. Can you imagine a situation like that? Although, let me be very honest, it's not as simple. It's the application, and I don't understand mathematics very well, but it's the application of vectors to mathematics and the combination thereof that is being patented. But let me give you a simpler example, which I can explain better. Patenting is being applied to, for example, again, Monsanto, that vile Changes Khan like corporate entity that I was talking about, which now Bayer has bought over. Made an attempt to patent a pig. Suar jo hota hai, hamara hog. They've patented a pig in the United States of America. Now, what do you mean by patenting a pig? ऐसा तो नहीं कि पूरे सुअर को बोल दिया है कि वो पेटेंट कर दिया और वो हमारा है. No, what they've done is they've patented a particular through genome sequence. I don't know who this is. Just 1 second. Yeah, through the genome sequence, they've identified a particular gene in the pig, which makes it fat. So what have they identified? There are gene markers in the genome sequencing. There are particular chemicals which lead to particular traits in particular species. So for example, if the color of my skin is the way it is, it's because of the existence of the presence or the absence of what is known as melanin. Now, how much melanin gets secreted by the body and what the color of the individual becomes and how. So you'll see that some people have patches on their skin where there is light and dark colored skin available. All of this is because of functions of the liver and enzymes which are being secreted. So everything is because of chemicals inside the human body also. So what Monsanto as an organization discovered was there is a sorry. There is a particular gene which makes hogs or pigs fat. They said we've identified this gene, we've patented this gene, and we can introduce this. You bring your non-fatty pig to us, we'll introduce this gene into it, and it will become a really big fat pig. So they patented this gene. One might think, what is wrong with it? The problem is that this gene naturally exists in over 30% of pigs all over the world. And in America, it naturally exists. But because a patent has been given to these people, anybody who has a pig which has that gene in it will belong to Monsanto, even if they have nothing to do with it. because they patented this gene, which is also a naturally occurring substance. What they have figured out is how to introduce it. But because of the manner of the patent legislation and the application of the patent that they have applied for, they have got a generic patent on the gene itself, which now means that you can get your patent on that particular gene and thereby own any other gene in which this patent, own any other pig in which this gene automatically appears. So we are looking at a situation where we are confronted with situations like this, where although nobody owns nature as such, attempts are being made to play God and own nature. The earliest attempts which were made was, there was a case called Diamond versus Chakrabarti. I don't want to go into the details. Then there was a case called Harvard Oncomouse. I'll tell you the Harvard Oncomouse case, very fascinating case. So research on what do you say, carcinogenic substances, or for example, or for that matter, any cancer curing drugs are done by research organizations. One of the research organizations that was doing field trials on mice was the Harvard College through its research and grant facilities. Now, what they did was they altered the gene of a particular mouse and its offspring to automatically create cancerous, cells. Now, otherwise, what needed to be done was you had to buy mice in the thousands, test them for cancer, find the cancerous ones, use them for research, and then whatever they had to do with the rest, they had to do. This is a very inefficient process and a very time-consuming process. So what we'll do is we'll create our own mouse and we'll introduce a particular cancerous gene in it so that we know all the mice that come from that gene sequence will all have cancer in them. So we don't have to spend money and dollars on trying to figure out which has cancer, which doesn't. The oncology department of Harvard, and therefore the mouse is called the Harvard Oncomouse or the oncology mouse. It always had cancer in it. They patented this. All right. Now there's a patent on a living organism because what have you done? You've taken a living organism, you've patented a particular gene sequence, you've introduced that gene sequence into a living organism, and now they say that this living organism is owned by us. Now we're playing God. This is a process of patenting and the application of patent, which is a very complicated, very moral repercussions that it has, and debates have been going on since the time we came up with Dolly the sheep as to who owns the clone, what will be the implications of, will the clone have rights of its own? So for example, if they create a clone of me, although it's my DNA, there is consciousness in that clone which exists, and therefore is it my ownership? Do I own that clone? Does the clone have rights of her own or his own? No, it can't be her own because it's my clone. So it will be an exact replica of me. So it will be a smaller Gokul, not called Gokul, but a smaller version of me as an infant. Do I own that infant? Does the company who did the mapping of the DNA become the owners of the clone? Does the clone have rights of its own? All of these are questions that the patent system is throwing up. Especially now with the advent of the technological phase, we are coming up with artificial intelligence. So it's becoming even more complicated. So that's about what I'd asked Manish to remind me about. Thank you so much, Manish. Now quickly, because we're running out of time, because it's such a complicated field and there's so much to explore and discover. The next thing I want to talk about is trademarks. A trademark, like the name itself suggests, is a mark which helps you remember an organization or a trade. So a trademark is, for example, this is a trademark. Where am I? Yeah, Body Shop. All right. It's a cream by Body Shop, and the trademark is the Body Shop with that logo on top. So it's a trademark. You can remember an organization by it. This is a trademark. Where did it go? 6, I can't see the trademark over here. Yeah, there. This is a trademark. Can you see Royal Enfield over there? Royal Enfield. Now that's the logo of Royal Enfield. That's a trademark. What is a trademark, therefore? A trademark is a mark that helps distinguish products of a similar nature and create a brand recall in the mind of the customer. So to explain myself, if I take out 3 or 4 types of salt and put it in katoris in front of you, as an average user, you and I may not be able to distinguish one salt from the next salt. For example, मैं अन्नपूर्णा नमक, टाटा नमक, कैप्टन कुक नमक और निर्मा नमक लाके आपके सामने कटोरियों में रख देता हूँ और बोलता हूँ कि आप पैकेट से निकाल दिया, मैंने बोला अब आप बताइए कौन सा नमक कौन सा है. It will be very difficult for the average person to figure out. Or if I put pairs of jeans in front of you, Wrangler, Spiker, Levi's, Uniqlo, and I just take the jeans, take the riveting off, take the logos off, take the center button off in which the logo is embedded, and take the zip off, and I just put the jeans in front of you, which is the product is actually the jeans. Most people will not be able to distinguish one jeans from the next one. It will be impossible for them. Same with shoes. Same with goggles, sunglasses. It will be difficult for people to distinguish products from one another. So the purpose of a trademark is through that mark to associate a product with a brand. मैं अगर आपको टूथपेस्ट निकाल के एक ब्रश पे डाल देता हूँ और बोलता हूँ कि मुझे बताइए ये टूथपेस्ट किसका है, सिर्फ देख के तो आपको टेस्ट की जरूरत पड़ेगी, शायद टेस्ट के थ्रू आप आइडेंटिफाई कर लो, लेकिन अगर सिर्फ मैं आपको दिखाऊंगा, इट विल बी वेरी डिफिकल्ट फॉर मोस्ट पीपल who don't regularly use that brand to differentiate a close-up from a Pepsodent from a Colgate and a Meswak or so on and so forth. It'll be difficult for individuals who don't have experience of that product. Same with Coca-Cola, Thumbs Up, Pepsi, Dr. Pepper, or whatever else you want to do. Or since you guys are from Pune, Frams, Cola, whatever. It'll be very difficult to distinguish. So what is the purpose of a trademark? The purpose of a trademark is to distinguish products of a similar nature and create a unique identity in the mind of the customer. Trademarks are also of various types and can be applied to systems like domain names also. A domain name can also be brought within the ambit of a trademark. A trademark can also be, variations of trademarks also exist, like sound marks. You can protect a particular sound also. For example, a trademark has been given to the sound, which is a sound mark, but a trademark has been given to the sound ting, ting, tiding. If you remember the sound, this is a Britannia ka sound. And similarly, the Yahoo Yodel, nobody uses Yahoo anymore, so you might not even remember the Yahoo Yodel. The Yahoo Yodel has been trademarked. The Nokia sound that used to come in when those two hands used to come to shake together, that's been protected under the sound mark. Similarly, there are smell marks also. To distinguish one smell from another smell, you've got smell marks also. So, for example, to be able to distinguish a Davidoff from a Burberry from a Chanel, all of these can be protected under smell marks. So that as soon as you smell, for example, a Davidoff cool water, you remember which the organization is, which the company is, which makes it, and you know that this is not the same as Clinique or DKNY or whatever it is that you guys use. So there's a differentiation in the product. So these are trademarks. The next one is geographical indications. Very unique, very different form of intellectual property, very different. The purpose of this intellectual property, all other forms of intellectual property are there to protect the rights of individuals and organizations and companies. This protects the rights of communities. What does it do? Unique product associated with a geographical territory brought together to provide protection. Let me give you examples. Kolhapuri chappal. So it's a leather slipper associated with a geographic, which has its own uniqueness. It looks very different from a Bata chappal. A chappal which is associated with a territory, Kolhapur, gives protection to the people who are manufacturing this product in that territory, and gives recognition to them. Kanjivaram silk, not Banarasi silk, not Kota silk, but Kanjivaram silk. Banarasi is protected separately, Kota is protected separately. Nagpuri oranges, Puneri pagdi, Agre ka petha, Mathura ka peda, Assam tea, all of these are forms of geographical indications where a unique agricultural manufactured product is associated with the place from which it originates and gives protection to the people of that place. So Kashmiri apples, all of these are examples of geographical indications. Product plus unique product plus geographical territory from which it emanates, and they have a combination of this. I'll just give you an example of a very unique one, which is Kadaknath chicken. Now, Kadaknath chicken, it's a fascinating thing. First of all, it's much larger. It's a murgi, matlab jo murgi khaya jata hai. It's a much larger chicken. Its plumage is greenish, dark, very dark, blackish, greenish blue. The meat inside the chicken also is very, very dark because it's very rich in iron. It has about 1.5 times the amount of iron that the regular chicken has. Kadaknath chicken is a geographical indication of a chicken which comes from the Chabua district in Madhya Pradesh. So what is it doing? It is giving recognition to a place with the unique product called the Kadaknath chicken. Chabua district gets the recognition for it. So geographical indications, unique product plus place. The last one, and then I'll throw it open to questions. I'm so sorry for taking so much time. The last one is the concept of designs. Now, designs are the outward appearance of things. So for example, I've got this mobile phone, which is a OnePlus 7 mobile phone. It's slightly dated now, but the outward appearance, the manner in which the camera has been put in, most of the screens look very similar from the front, from the back, and the appearance. All of this is protected under the Designs Act. This miniature model of the Royal Enfield Classic is protected under the Designs Act. Now, this basically is the outward appearance, which makes it look different from, for example, a Benelli, or it makes it look different from a Java or a Yazdi. The shape of these products can be protected under the Designs Act. So it should be easily distinguishable to the human eye. So I can take a shape from anything and apply it to another product. So for example, अगर मैंने एक lighter बनाया कुतुब मीनार के shape में. So कुतुब मीनार is a shape which can be seen by anybody, but I've taken that shape and I've applied it to a lighter. I can protect that under the Designs Act. The shape of this bottle, there's a particular octagonal shape to this bottle with a unique shape to the dhakkan. This can be protected under the Designs Act. The shape of this pen, for example, can be protected under the Designs Act. One of the first things that was protected under the Designs Act was the shape of you remember that white and blue Reynolds pen? It was a very, I don't know if you guys use Reynolds anymore. It's not that popular because gel pens have become more popular. When I was a student, Reynolds and this company called BIC, BIC is what I used to call it. Both of these were very, very famous pens and very fluid. It was called a roller ball pen, but it was a ballpoint pen. It's called a ballpoint pen. आजकल जेल पेन्स are much more famous, so I don't know. आजकल in fact लोग लिखते कहाँ हैं, तो ज़्यादा लिखने की ज़रूरत ही नहीं है, तो I don't think pens are that popular. But back in the day, it was very popular. The shape of the Reynolds pen was very unique. It had a blue cap with a dundee like that and a white body. That was protected under the Designs Act. The Pilot pen was protected under the Designs Act. Again, these are pens which you may or may not have knowledge about or access to. So design protects the outward shape of things. It can be applied to 2D or 3D content, right? So that's the basic introduction I wanted to give you to the various forms of intellectual property. I'll do a very quick overview. Copyright to all kinds of literary, artistic, dramatic, cinematographic films, sound recordings, and software. All over the world, software is protected under copyright, apart from United States of America. In United States of America, software is protected under patent law. Patent law protects technology, and USA thinks software is technology. India and the rest of the world thinks software is copyrightable. And I'll tell you what the logic over here is. The logic is, since software is written in a code, and since code is nothing but a language to communicate between a machine and a human being, language is a purpose of communication. Like English is a language in which English and Hindi are languages in which I'm communicating with you, for two human beings to interact with each other. And therefore the creation that comes out of the application of the language becomes copyrightable. The world over thinks that logic can be applied to software also, because they are written in a particular language: C, C++, Java, Basic, COBOL, Python, Ruby on Rails. I don't know, whatever language you want to use to create that interaction, that software. United States of America, on the other hand, says that it's a scientific invention. It's a novel creation, and therefore it should be protected under patent law. Just a unique fact that I wanted to tell you. Patent protects technology. Then comes trademarks, which protects logos, color combinations, symbols, tickets, and things like that. Purpose of a trademark is to protect and distinguish between products of a similar nature and create a unique identity for a brand in the mind of the customer. Then comes geographical indication, which is a community right, unlike other forms of intellectual property. And the purpose of it is to create a unique identity in the mind of the customer with respect to a particular geographical territory. Right? Then comes design, which is basically the ability, a law that protects the ability of the human mind to distinguish visually between products. And so basically it is on the shape or outward appearance of product that this protection is given. These are the 5 forms of intellectual property that I wanted to introduce you to. Yes, now we may throw it open to questions. For those of you who wish to leave, please feel free. If you've got prior engagements, I understand I had time only till 1:30. I'm sorry for exceeding my time. I apologize for that. I have another 10-15 minutes available. For those of you who are interested, please feel free to continue asking questions. And for those of you who have prior engagements, you can ask college's permission and then do the needful.
So sorry to interrupt. Attendees, before you leave, we'll be circulating a feedback form. The QR code of the same will be shown and also will be sent in the chat box. So before you leave, make sure you fill it up in order to receive your certificates.
No, I was not asking you to say whether you're going to leave or not. I'm saying ask college's permission and do whatever you want to. Don't feel compelled to continue over here. That's what I meant, Manish. I apologize.
Yes, sir. Yes, sir. Not a problem.
Yeah, please go ahead. Questions for those of you who have not been able to address questions from. Yes, Shambhavi, please go ahead.
So I wanted to ask, in what way can granting protection for a finite term serve any purpose?
Granting protection for a finite term?
Yes, so like the patent site is for 20 years and then.
Correct. Very good question again. The purpose of a finite term is so that people don't keep commercially exploiting or आप artificial monopoly create कर रहे हो. आपने for example एक drug create किया to cure Alzheimer's. Now, if I'm the only person who's manufacturing the drug, that means the world at large cannot benefit from it. मैं तो ड्रग वहां पे बेचूंगा जहां पे मेरे पास इजी एक्सेसिबिलिटी होगा, जहां पे सबसे ज्यादा मुझे लगता है प्रॉफिट बनेगा. एंड क्योंकि मैं कॉस्ट ऑफ द प्रोडक्ट अपने पैसे बनाने के लिए ऊपर रखूंगा, द एवरेज पर्सन ऑन द रोड मे नॉट बी एबल टू receive the benefit of it. But after the period of 20 years monopoly where I've made my money is over, then the law will give this formula that I have created to other people to start manufacturing at whatever cost they wish to. Please remember, when I'm creating a product, I have to factor in cost of manufacture along with research and development plus profits. But when the product goes outside the patent protection realm, then all you need to think about is cost of manufacture and maybe marginal profit. Research and development and extensive profit की जरूरत ही नहीं है क्योंकि it now becomes a generic drug and everybody is producing it. Like for example, Brufen. Brufen is a what do you say? Muscle relaxant plus a painkiller. So basically it comes as a block between the nerves and the area in which the pain is created, so that it creates a block. It creates a chemical block on top of the nerve, which basically then does not send the pain signal from the affected area to the brain. But now this drug is no longer under patent regime. So there are various manufacturers, SmithKline, Beecham, Johnson & Johnson. There are various manufacturers which under their own brand name are producing Brufen or Ibuprofen or whichever version of Brufen it is, which has brought the cost of the drug down, therefore limited protection. So that exploitation does not happen for an unlimited period of time. I hope that answers your question.
Thank you, sir. Yes, sir.
Yeah, go ahead. Next, whoever, please.
Next, we have Atharva.
Yeah. So, sir, I guess it was really a great session, first of all, and I have a question on trademarks.
Please.
So, so now everyone is witnessing the revolution of metaverse, and I guess to protect their trademarks and infringements. So many shops and brands are opening up their stores in metaverse. I guess H&M was one of the first one to start with it.
Yeah.
And many influencers and entrepreneurs are investing and organizing events in metaverse. Yeah. And as we are saying that metaverse is the future, so how are brands protecting their trademarks from infringements and violations over there?
So what basically is being done is a very fascinating question again. Although the metaverse, and this is where law and technology is always at loggerheads. It makes it a very fascinating place for us to study intellectual property and for becoming lawyers or experts in the field of intellectual property. And that's why intellectual property is going to be a subject of the future. Everybody needs to know it. It doesn't really matter whether you become a copyright, become a digital creator or anybody else, because you'll need to understand how copyright works or intellectual property works. Now, the question is, मेटावर्स में अगर इंफ्रिंजमेंट होगा तो उसका प्रोटेक्शन कैसे करेंगे और कहां करेंगे? So the response to that is, law, however, functions as of today in the physical realm. Our law is applied in the geographical territory enforced by a governing authority like the judicial system. Even if the violation takes place in metaverse, the law is broad enough to establish and protect the rights in the virtual world through the laws in the real world. So आप कोर्ट के पास, यहाँ पे डिस्ट्रिक्ट कोर्ट के पास या हाई कोर्ट के पास या सुप्रीम कोर्ट के पास ही जाओगे अपने लॉ, अपने राइट को एनफोर्स करने के लिए जो इन कानून द्वारा आपको दिया गया है. So if there is a law which protects your right of the trademark, the right is protected irrespective of whether that right exists in the real world or the virtual world, because that's how the trademark law has been drafted. So you will still go to the regular courts to say that my rights in the metaverse have been infringed and I want to protect these rights, and so and so person who's using my trademark without my permission in the metaverse should hear as of now and for in the future be stopped from doing so, and I can sue that person in the real world. Yeah.
Yes, sir. So like if in future, like let's say courts move on to metaverse, so is there a possibility that the the cases and all might get resolved in metaverse itself?
There could be a possibility, but it will not be a similar kind of system that exists over here. See, because at the end of the day, you're still requiring the application of a human intellect. As long as there is applicability of human, what is referred to as intelligible differentiate, the ability to differentiate between things, as long as that is there, whether it is applied in the real world or the virtual world, it should not make a difference. As of right now, it does not exist, but I can see a future of judicial systems existing in the metaverse also. But at the end of the day, आपको apply तो यही करना पड़ेगा. What will be more challenging is the use of artificial intelligence for settling disputes based on an algorithmic assessment of facts. Now that will become more complicated because to be able to use the idea of emotion is something that we've not figured out in artificial intelligence. So there is a scope and applicability of artificial intelligence for contractual disputes which can be commercially weighed, but for disputes which are more emotional in nature, like for example child custody. There is a lot of stress, emotion, vulnerability which is involved. Artificial intelligence may not come in. So artificial intelligence, I think, will be a more complicated field, and its development through intellectual property will have to be watched, especially in the field of judicial pronouncements. Yeah.
Yes, sir. Thank you so much.
Welcome. Next.
Good afternoon.
Yeah.
Good afternoon. I'm Dr. Swati Chine, Head
hi,
of Department of Business Laws. It was a privilege listening to you, Mr. Gokul. After a long time, if you remember, once upon a time, I had invited you for delivering a talk on cyber security.
Yes,
I would like to ask one. Yes. It was really a privilege. It is a wonderful talk going on. So I would like to just ask you one question. What is your take upon protection of copyrights, especially? According to me, because I think so, copyrights are the most difficult IPRs amongst all the forms to get protected. So what is your take on that?
Ma'am, I completely agree, ma'am, because copyright becomes, first of all, difficult for people to understand itself. For example, I think there is a violation of copyright that takes place in daily life of a student. In the daily life of a student, we violate copyright, whether it is taking a photograph from the internet to use for a project, or it is taking information from Wikipedia to put into our research paper. Every day that violation takes place. So copyright as a law is more loose and variable, and therefore it is more difficult to protect. And I completely agree with you, ma'am. I could not agree with you more. Copyright as a system of laws becomes more difficult to protect, and therefore a large majority of copyright violations go unregulated and unprotected. Only very severe cases of copyright violation done in the public eye by renowned people get within the ambit of the law. Otherwise, most just मैं अगर कोई copyright violation करता हूं तो I'm insignificant enough not to make a difference to the larger commercial aspect of things, and therefore it will not be relevant. So, for example, if ma'am, as opposed to me, if the same violation, copyright violation, publicly is done by Amitabh Bachchan, it will create a problem, because his copyright violation may have commercial ramifications for the person who's created this content, and therefore he might take this violation far more seriously. He or she might not even notice me violating his or her copyright because I'm irrelevant. So copyright has various nuances to it. Hopefully we'll get an opportunity to discuss these nuances tomorrow in our session, ma'am.
Yes, sir. Thank you so much. That's what I wanted to tell you. Please elaborate on this part of legal remedy in case of violation of copyrights, maybe in tomorrow's session.
Absolutely, ma'am. I intend doing that.
Tomorrow, yes, sir. Tomorrow we have full 2 hours dedicated for copyright.
Yes.
And
Yes.
More detailed in this, and also we have a lot of students, as you said, who are into content writing and a lot of these artistic things.
Yes.
For whom I think copyrights could be of a very big use.
Absolutely.
So can we conclude the session now, because
absolutely.
It's already, yeah.
Absolutely, ma'am.
It's so interesting that students, there's a lot of curiosity among students, so they will join back tomorrow, and maybe they can listen to you tomorrow and ask you questions tomorrow itself.
Ma'am, so if possible, what we could do is, ma'am, if required, we can have a longer Q&A session tomorrow if the students are free. For those who I'll keep, because today I have another session also which is starting off, but tomorrow I'm relatively free and I can continue answering questions for those who have questions. I apologize to everyone. I had a lot of content to cover, so I've not been able to address all your queries, but I shall certainly do so tomorrow.
Sure. I know you had briefed me earlier that it's a very vast topic and cannot be covered in 2 hours. But sir, I think you've done an excellent job. I mean, students are glued to Teams. That shows that it has been so interesting. Thank you so much.
Thank you, ma'am. Thank you, ma'am. Thank you.
Okay, so then we can go Okay, concluding the session.
Yes, ma'am. Yes, please.
Okay, so I thank Mr. Gokul Narayan for explaining the concepts of copyrights, patents, trademarks, geographical indications, designs, and everything else in between in such a crisp and clear manner, and also for interacting with the students. I'm confident that this workshop has helped us all in learning about various and new concepts of IPR which were previously unknown to us. I for one surely did learn a lot, sir, and for that I'm grateful to you.
Thank you. Thank you.
I would now like to invite Dr. Nilesh Wagmare, sir, professor in charge of this program, to deliver the vote of thanks.
Nilesh, sir, good afternoon.
Good afternoon, sir. Thank you, Manish. Good afternoon, everybody present over here. After this brilliant session on intellectual property rights in digital era, now we come to an end of the day one of this workshop on intellectual property rights. On behalf of the Department of Business Laws and Center for Innovation and Entrepreneurship, I take this opportunity to propose the vote of thanks. To begin with, we would like to extend our sincere thanks to the speaker of the workshop, Mr. Gokul Narayan. Sir, thank you so much for throwing light on the various relevant aspects of intellectual property rights in digital era and answering all the questions with a lot of familiar examples in very lucid manner. Thank you, sir. We would like also to thank Rashtriya Uchchadar Shiksha Abhiyan, RUSA 2.0 for providing us the funding. We thank our principal, Dr. Rishikesh Suman, for his ending guidance and support in organizing this online workshop. We must mention our words of gratitude to our Vice Principal, Dr. Tracy Thadtil, for her ever silent and strong support and motivation. We thank Dr. Anil Adagre, IQAC coordinator of our college, for his all administrative support in organizing this event. On top of this, we are really thankful to our student participants for being active attendees throughout the session. And last but not the least, that is our student volunteers. Varun Deshpande, Atharva Tidke, Divyanshu, Manish Agarwal, Asta Kumar, Varun Mohan, and Gautami Rane for their instant help in smooth conduct of this workshop. Thank you all. Have a great day ahead. Thank you.
Thank you.
Thank you
so much.
Tomorrow, we will see you tomorrow.
Yes, absolutely. I look forward to tomorrow's session. Thank you so much.
Swati ma'am is also here. So Swati ma'am, thank you all.
Yes,
Thanks
thank you, sir. Thank you, Mr.
Thank you.
Nish.
Thank you. Thank you, ma'am.
Thank you, sir.
Yes, thank you.
Bye-bye.
Sir,
all are
Let's
in
see
our
you all tomorrow.
stations.
everybody's clapping for you, sir. Look at this.
Thank you so much. Thank you so much for the appreciation, guys. Thank you so much for listening. I cannot say enough how much it means when people ask questions. Because like I was saying, it makes our work as teachers, as people who are trying to interact with you a lot more convenient when there is enthusiasm from the other side. We get motivated to speak. So thank you so much. I'm very obliged with the participation. Thank you.
Thank you so much, sir. Thanks a lot.
Bye. Bye. Have a great day. I'll see you all tomorrow.
See you tomorrow.
Thank you, sir.
Bye-bye.
Thank you, sir.
Participants, you are requested